We have 17 bills, believed to hear, and we have to adjourn at noon. So if Senator Leno would take his seat, we would have a subcommittee. And I'm asking, as we begin today, that authors should please keep your presentations brief. We've all discussed your bills and read the analysis, and asking that there be 2 witnesses on each side, and then me twos, and no more than a minute each, please. We do have an author with us. Yeah, I'd also like to just announce that 2 bills have been pulled from today's calendar. SB 448 by Senator Galgiani. This has become a 2-year bill. And SB 507 by Senator Pavley, which will be reset for next week. Good morning.
3191.
That, I know, that happens. Good. Now we have a complete subcommittee, so that's good. Senator Block. This is item 1, SB 213.
Thank you, Madam Chair, committee members. SB 13 deals with peremptory challenges. It increases efficiencies in jury selection by reducing the number of peremptory challenges only in misdemeanor trials from 10 to 6 per side. It also reduces the number of additional challenges from 5 to 2 when multiple parties are jointly tried. Now, even with this change that we propose, California, this is important, California will still have more peremptory challenges than 47 other states. So we're clearly the outlier. U.S. jurisprudence deems that we have many more than enough peremptory challenges to guarantee fairness. And still, of course, there would be, under this law, unlimited challenges for cause. This doesn't affect that at all. Due to recent budget cuts, we all know that the courts have been hurting. They've cut back personnel. They've closed entire courts. With the passage of Proposition 47, there will be thousands of resentencing hearings. There may be felonies changed to misdemeanors and charged that way and heard. That only makes things more complicated for the court and, frankly, makes this bill all the more important. One way to help is for us to modestly reduce the number of peremptory challenges, and again, remembering this is only in misdemeanor trials. I'm cutting down what I'm saying, Madam Chair. And we do have evidence from actually a study done by George Mason Law Review, Roger Allen Ford, where he quotes Justice Breyer as saying, Justice Breyer recognized in 2005 the use of race and gender-based stereotypes in the jury selection process seems better organized and more systematized than ever before. So the allegation is in this Law Review article that having lots of peremptory challenges, and again, we're the outlier, 47 states have fewer, having these many peremptory challenges actually allows attorneys to discriminate more on the basis of race, gender, sexual orientation, et cetera, in their jury selection. By cutting down the number of peremptory challenges, hopefully we're cutting down the likelihood of such discrimination. Shortening the jury selection process, of course, will also provide justices, jurors more time to decide certain cases. They'll have more money the courts will have more money to process complaints that come from the public, more money to handle serious felony charges. It'll save millions of dollars annually for public and private employers as well. You see, as we all know, when we serve on jury duty, we're away from our business. Now, if you work for the government or you work for a very large corporation, that may not have an impact. But for our small business people who we care so much about in California, having people on jury duty where they're just sitting and waiting because of the relatively huge numbers of peremptory challenges in California is terribly inefficient for California's economy. SB 213 is co-sponsored by the California Judges Association and the Judicial Council. It's also supported by many Superior Court judges across the state. We've distributed a partial list to you. The bill this year is for the first time supported by several district attorneys as well, including Bonnie Dumanis from San Diego, and also the DAs from San Francisco and San Mateo County. The California District Attorneys Association is neutral on the bill. I have several witnesses here to testify, but having heard the chair's direction that we have only 2 witnesses, I will ask them to testify briefly.
Thank you.
Good morning, Senator Hancock, Senator Anderson, and other members of the committee. My name is Judge Suzanne Bolanos. I'm here to testify in support of SB 213, which has been endorsed by the presiding judges from all 58 counties in California, as well as the Judicial Council of California. The judges in California overwhelmingly support this legislation because it will not only save valuable court time and money, it will save money and resources for the entire community. In San Francisco, where I have been a trial court judge for over 11 years, this bill is of particular significance because the majority of criminal cases that we take to trial are misdemeanor trials. To give you some context, in the first 3 months of this year alone, 4,176 jurors were summoned to the San Francisco courthouse for misdemeanor trials only. The average length of these misdemeanor trials is 6.9 days. Commonly, 2 misdemeanor trials are sent to one judge to be heard simultaneously, one in the morning and one in the afternoon. For each one of these trials, we, the courts, have to summon enough jurors to allow for the possibility that the people and the defense will each exercise 10 peremptory challenges. Reducing the number of challenges will allow us to summon fewer citizens for every misdemeanor trial in the future. Now, each additional juror that we summon represents a cost to the courts. The staff and mail expense of summoning the juror, the staff burden to check in each juror and assign the juror to a panel, the per diem reimbursement that the juror is entitled to under the law, and the cost in staff, judicial resources, and court security of lengthier trials than warranted. Now, the cost to the courts is just the beginning. There are tremendous and very real costs to jurors and to their employers. Significant numbers of jurors are teachers, small business owners, and minimum wage employees. Jurors often are not paid by their employers for their time away from work. Every hour that these jurors serve is an hour of foregone income, a real burden to working-class families and single parents. And even if the jurors themselves are paid, the cost is simply passed on to the employers, who lose the jurors' services and productivity. Reducing peremptory challenges in misdemeanors only saves tremendous money and resources for the entire community without compromising due process. While this modest reduction to 6 challenges per side would be consistent with the number of peremptories allowed in the largest and most complex civil cases, it still allows for more challenges than in federal court and would bring California into alignment with the courts in 47 other states. As a former trial lawyer and now as a judge, I'm confident that reducing the number of peremptory challenges will not have any effect on securing a fair and impartial jury for every misdemeanor trial. We excuse for cause any juror who evidences any prejudice or bias before the attorneys exercise the peremptory challenges which are the subject of this bill. I urge you to vote in favor of SB 213 for the benefit of the courts and the citizens of California. Thank you.
Madam Chair, good morning. Members of the committee, good morning. I am Steve Wagstaff, and I am the District Attorney of San Mateo County, and I speak to you today in that role. I have been a prosecutor for 38 years. I have tried cases for all of those 38 years, and I do believe that jury trials are the lifeblood of our criminal justice system. It is a crucial component to justice, and liberty is always, for the defendant, is always a crucial item that we should protect and provide due process. I believe, as Senator Block said, this, though, in SB 213, is a modest proposal. I have studied it. I had the natural reaction when I first heard about it, as prosecutors do, well, I'd rather have 50 challenges than that. But we recognize that we are working in a time where efficiencies are needed. And this is an efficiency that will benefit not just the court and the other people that Judge Bolanos referred to. It will assist so many of us in law enforcement. And what do I mean by that? I'm thinking of, in every misdemeanor case, you have to be ready to go. As soon as that jury selection is done, you have to have your officers, and it's usually officers on misdemeanors, you have to have them ready to testify, which means they may be sitting there for several days while jury selection is going on. And therefore, it's the time used for them. We will save in that line when there are fewer challenges. Now, my concern, of course, would be by moving from 10 to 6 challenges, are we taking away from that ability of both the people and the defense to have a fair and impartial jury? I'm a big believer in the use of peremptory challenges. Cause challenges are very good, but they can't always get to the core of a hidden or implicit bias. So they're important. But I think in misdemeanors that is 6 challenges that's been shown around this country, that 6 challenges are sufficient. I check to see how many, how often, and this is anecdotal, I grant you, but how many times are we using more than 6 challenges in my misdemeanor cases? And my prosecutors tell me not that often. It's not that often. However, you have to bring in that full panel, exactly as Judge Bolanos stated, and that just is not an efficient thing. You know, with Prop 47, I can't speak for the big urban counties, but I'll speak for a county of 750,000 in mine. Prop 47, 1/3 of our felony cases are now misdemeanors, and our misdemeanor trials have gone up. So it becomes even more of a relevant point for us to be able to do it. But 6 peremptory challenges accomplishes the goal. This is a modest proposal, as the senator says. It's not the first step in moving it everywhere else. And I know that may be a concern for some as well. The next step will be this, but that's not what is before you. This is a step that I think serves the public well. I think it preserves due process and a fair trial. And I very much believe that it would be a very, very appropriate step for our state to take. And I do this in support of both the judiciary and in support of the public. Because there's nothing I see every day around noon when I see, you know, maybe that couple hundred jurors walking out with that angry look on their face, saying, I sat there and nothing happened. I sat in the basement waiting, and then they didn't need me, and a whole new group comes in the next day. We can be more efficient, I believe, while preserving it. And for that reason, I join Senator Block in asking you to support this bill. Thank you for listening to me.
Of everybody being here to establish the quorum. Would you please call the roll?
Hancock.
Here.
Hancock here. Anderson. Here. Anderson here. Leno. Here. Leno here. Lou. Lou here. McGuire. Here. McGuire here. Moaning. Here. Moaning here. Stone. Here. Stone here.
Thank you. Okay. Are there others in support of the bill?
Chair and members, Dan Pong for the Judicial Council. We're proud to be a co-sponsor of this year's bill, and we urge your aye vote.
Thank you.
Deputy District Attorney Laura Tanney, on behalf of Bonnie Dumana, San Diego County District Attorney, in support.
Judge Joan Weber, President of the California Judges Association, in support.
Others in support? Are there speakers in opposition to the bill? Seeing and hearing none? Sorry. Please come forward. You each have a minute. I think we may have gone over. Go ahead. No.
Equal time for.
Yes.
Hi, I'm Matt Gonzalez. I'm the Chief Attorney of the San Francisco Public Defender's Office. I've been an attorney for 25 years. I'm a graduate of the Stanford Law School. I've tried civil, criminal, federal civil rights cases, and I served with Senator Leno on the San Francisco Board of Supervisors. I think it's important to contextualize what this measure does. The cause challenge system isn't working, and it hasn't been working since about 1991 when Proposition 115 took effect. It's not working because attorneys get, in a misdemeanor case, get 15, or if they're lucky, 30 minutes to question jurors about potential bias. That's about a minute and a half for each juror to discuss burdens of proof, due process, and specific bias on a case. Additionally, judges will often take a prospective juror that says, well, gee, my cousin was killed by a drunk driver, and they'll say, well, that was a long time ago. Can you be fair if I ask you to be fair? And when they say, well, I guess I can be fair, I can be fair, the judges deny challenges for cause in those instances. Preemptory challenges are important because it allows the attorneys to do the work that the judges are no longer doing. And in fairness, the old system before Prop 115, voir dire could take days. So there was a need for reform, but now it's gone too much the other way. I wanted to address a couple of things I heard. 47 other states may have less preemptory challenges, but the question is, do 47 other states limit voir dire to the extent that California does? These things are tied inextricably. Also, the length of trials that you hear about in a misdemeanor case, that's including jury deliberation, and it's including the fact that trials are often half-day trials. So trials don't typically take 7 days to conduct. And finally, the jurors that are called to participate in the selection process in the event that the attorney may use all 10 preemptory challenges, when they're not selected, they don't leave the courtroom angry. They leave the courtroom having participated in our democracy. It's a civics lesson that they get to participate and listen to while they hear the attorneys fighting over these important issues. And as the gentleman next to me indicated, it's quite uncommon for all of the preemptories to be used, so why take them away when they are necessary? It makes more sense to leave the system in place. If you are going to pass the measure, I would ask you to include something that says voir dire should be given at least 15, 20 minutes per prospective juror. You should have 3 or 4 hours to question jurors about bias, not 15 or 30 minutes.
Thank you, Madam Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys. We are also opposed. Let me clarify a couple of points. Number one, you hear a lot of discussion today about misdemeanors. Oh, they're misdemeanors, very subtly suggesting that they're just misdemeanors. Let's be very clear, and I have a list put out by Judicial Council of more than 50 pages of misdemeanors in California. Some of them are sex crimes requiring lifetime registration. Some of them have a firearm restriction that go along with the conviction. Many of them will result in loss of job. Many of them will result in a number of other lifetime consequences. So there's a lot at stake when someone goes to trial on a misdemeanor. Most misdemeanors are settled well before trial. We know that. But when they go to trial, there's an issue of innocence or there's an issue of the consequence. And so there's something at stake. So let's be real clear not to just dismiss that it's only a misdemeanor, because for that person, it's extremely important. A couple of other things on cause. As the gentleman just spoke, the use of cause is problematic. Let me tell you this. I was put in a jury box. I was questioned by the judge more than any other potential juror of whether or not I could be fair or whether I'd be biased. And the judge tried everything possible to extract from me that I would be biased in the criminal trial. I see some smiles because I probably felt the same way. And they could not kick me for cause. The DA almost broke his leg and, running back to his notes to make sure that he used his peremptory challenge to get rid of me. And what that shows is that cause is very narrow. You essentially have to get a potential juror to admit that he or she is going to be biased within one of the categories that's listed in statute. And if you can't do that, then you have to rely on peremptory challenges. And as Mr. Gonzalez stated, it's because attorneys are restricted. Let me talk about defense attorneys. We are restricted. We are controlled by the judge on how much we can ask, if anything, of potential jurors. So as long as the judge has all of the authority, then we have to rely on peremptory challenges, and you are taking away this tool from us. Let me just close, because I know there'll be a lot of questions. I won't get even into the issue of efficiency, because let's be clear, it's not efficient for someone who is on trial. And we've talked a lot about court efficiencies. I support court funding, but having an efficiency that's focused on the rights of criminal defendants and the ability to get a fair trial is not where we should begin. That should be the last place we go. And let me tell you why. I've sat next to, I've worked with, I've represented individuals who are on trial for misdemeanors and felonies, but misdemeanors. And let me tell you this. They are individuals, for the most part, especially those represented by public defenders. They're in poverty. They come from broken homes. They're foster kids. They've never gotten a break. They're in terrible schools. Yes, maybe they've done something wrong. But to each one of them, you know what they tell me? That one moment when they're sitting in court, when they're scared, the police officer's there, the judge is there, the bailiff is there, the one moment that shines for them is that someone's advocating for them and they have a right to be heard. They're presumed innocent, and they have to be proven guilty beyond a reasonable doubt in front of a jury of their peers. It is the one moment where the promise of justice is actually delivered for every single person, regardless of how they look, regardless of how they talk, regardless of their background. And it is at that moment we have to assure that the jury is going to be fair. Peremptory challenges, or taking away peremptory challenges, runs the risk that at that moment, when it's most critical, you may not get an unbiased jury. And it may not be efficient for judges. Well, I'm sorry. That's their job, and that's their responsibility, whether it's a misdemeanor or felony or capital murder. That's their job. And if it takes them too long, I'm sorry. Thank you for doing your job. Thank you for delivering justice for every single person. Protect these peremptory challenges. They don't save money. The only thing they do is run the risk of more biased juries and more people being convicted of crimes they didn't commit. I ask for your no vote today.
Thank you. And Me Too's. Are there others in opposition?
Jesse Stout, Legal Services for Prisoners with Children, opposes this severe reduction in peremptory challenges.
Okay. Others in opposition? Seeing and hearing none. Are there questions or comments from members of the committee?
Madam Chair, I'm prepared to move the bill when you're ready.
Okay. The bill has been moved. Senator Monning.
Yeah, a question for the author or anyone on the panel. We heard that there's been an increase in misdemeanor charges because of Prop 47. If this were to pass, would there be a decline in those subpoenaed to do jury duty? In other words, I think the first judge who testified, could you maybe address how you see this affecting the number of people being, the rate by which people are subpoenaed to do jury duty?
Yes, and I'm Judge Bolanos from San Francisco. Yes, for each misdemeanor trial, we currently have to call in enough jurors with the assumption that each side is going to exercise their 10 peremptory challenges. Even if, in the end, they don't exercise those peremptory challenges, we have to be prepared for that possibility and have enough jurors called into the courtroom for that possibility. If this bill were to pass, and we're now seeing more misdemeanor trials as a result of Prop 47, we would only have to call in enough jurors to allow for the possibility of 6 peremptory challenges per side. So it would help us and save court time and money, as well as community time and money for teachers and other people who are called in for jury service, for law enforcement, for anybody who's going to be called in for jury duty. If we call in fewer people, it's going to save time and resources for everyone.
Thank you. Madam Chair, if I think the opponents are frothing at the bit to address the same question, would that be appropriate through the chair?
Yeah.
Thank you.
Senator, I do agree that it would require less people to have to come for jury duty. But to give you an idea, I think the number of cases, what you're hearing is, it's not what you're hearing. Right now in San Francisco, a city of nearly 1 million people, there are 2 misdemeanor matters in trial. I checked the board as I was leaving this morning. It's not what you think. It's not like this And Prop 47 has already taken effect. Those cases are already in the misdemeanor courts.
Madam Chair, to the question of Senator Monning, it could reduce the number of folks that are called in, but what could reduce it more and it would create more efficiency is if counties throughout the state adopted the procedure that they have here in Sacramento County, for example. If you're called for jury duty, you don't have to physically appear. What you do is you go online and check by category your particular number when you have to go in. So you may be on call for a number of days, but you're not sitting in the courtroom. You're simply checking it at noon, you're checking it in the evening, and then they let you know whether to come in. So that's one efficiency. The other efficiency, if you really want to take care of jury trials, is you ensure that every courtroom is open 5 days a week for trials. I promise you, like for example, there was a case that settled yesterday here in Sacramento County, early in the morning, and the courtroom was dark for the rest of the day, which the lingo means that it wasn't being used for anything the rest of the day. So there are other ways to capture efficiencies. And in my initial comments when I said, if you want to talk about efficiencies, this is the last place to start. Let's tackle other administrative procedures to get efficiencies in how we handle juries, as opposed to going straight to the core of whether we're getting fair juries or not. That's our major, major objection. This is the last place to go.
Thank you. If I could just, final question. Does anyone have data in misdemeanor trials? In how many misdemeanor trials are more than 6 peremptory challenges used?
Does anyone? I will tell you, sitting here, it's striking to me to realize how little data we probably have. I would point out to the committee that this bill did pass out of this committee last year. It had a 2-year sunset on it. This year, the bill has a 5-year sunset. In talking to individuals, they indicated they might be willing to go back to a 2-year sunset. But what I'm noticing is not in the bill is any collection of data that would inform us at the end of that period of time about exactly this sort of thing. How often are they used? I think the jury selection system that you've mentioned, Mr. Hernandez, may be in effect in many counties. It's also used in Alameda County. I don't know if there are any counties that make people go in and sit for a week. Does San Francisco do that? What county are you?
San Mateo County.
San Mateo County.
We're on a one-day system, as so many counties are. Jurors come in for
But
1 day.
people do have to come in regardless of whether or not they'll be called?
Yes, for the 1 day that they are. They may get called off, they call the night before and check to see is a panel still needed, but absent that, they come in. We have
Oh,
jurors
okay,
coming in.
that is what Alameda County does.
Yes, and that's what we do in San Francisco County
Okay,
as
so
well.
it's a one-day system.
Yeah, and even in the call-in system, Madam Chair, you know you can't leave town. Once you've committed to jury duty on that day, what you're doing at work is marginalized because you can't take meetings that are important. You need to be prepared to go in if you get called.
Madam Chair, we fully intend to collect all of the data that you're requesting and that is being discussed.
But it ought to be specified in the bill. Otherwise, when 5 years are over, it will turn out some places just didn't realize what they were supposed to do.
We're
is-
happy to.
Yeah, Madam Chair, if
make that
there's an amendment
amendment.
proposed by the committee, the author would accept that to include data collection.
Yeah.
It might be best to take that as we get to the floor.
Okay, I think it is better to put it in now. So okay, so the data collection would go to judicial council, but what data is going to be specified? For me, I'm very interested in the number of times the challenges would be used, okay? And what the misdemeanors were that go to trial. And I'm interested in that because I have to say that when I heard all the opposition to Prop 47, from law enforcement, it was that nobody ever went to trial for a misdemeanor. A misdemeanor was nothing. Now we're hearing 4,000 misdemeanors tried in San Francisco. I don't think we actually have looked as a legislative body enough at how many are there really, and
Madam
what
Chair.
are they for, and what are the consequences?
We have a witness who can speak to
Okay,
data collection by
thank
the
you.
Judicial Council.
Chair and members, Dan Pone for the Judicial Council. Would be happy to work with staff on language to figure out the most appropriate study to collect the data that you're interested in and do it in a way that's as workable as possible.
Madam Chair, just to correct the issue, there are not 4,000 misdemeanors that go to trial in San Francisco. I think last year was less than 100, probably 6 or 7 in a month. I think one year we recently broke 100, but it's probably 4,000 total charged.
We've called in 4,000 jurors for misdemeanor trials only in the first 3 months of 2015. And in the first 3 months of 2015 in San Francisco, we have had 81 misdemeanor trials.
Senator Leno.
Thank you, Madam Chair. As the author well knows, I did not support an earlier version of this bill that was authored by our former colleague, Senator Evans. But I did have a couple of questions. If I could, District Attorney Wagstaff, the position of the California District Attorneys Association has changed from opposition to neutral this year, and I wouldn't expect you to speak for the association.
That's right.
But I was just curious, were you also in support of the bill when Senator Evans authored it?
I was never involved in that discussion.
Okay. Did you have a position on it if you weren't at the table?
Yeah, for Senator Evans?
Yes.
Candidly, I probably would have opposed it, because the change for me was, I thought 5 cutting in half, even though it's just 1, was getting too low. And additionally, there was no, the sunset I thought was too narrow to truly get it, because one of the things that we're going to do as a DA's association, in addition to whatever is in the bill, is we're going to collect our own data, and hopefully able to get that too, because data is very important to me to see what impact it had, so that I could come back in 5 years with some true data to say, yes, it works, or no, this has been bad.
And do you know how many misdemeanor cases there are in trial currently in San Mateo County?
2.
Two
Same as
also.
that, 2. Our trouble is that due to our settlement approaches, on Monday of this week, which would have been yesterday, we had something like 35 misdemeanors set to go to trial. And that's where our courts have to anticipate, well, we could have 5, 7, 8 go out.
Right.
So they have to anticipate that with jurors coming in.
It does appear evidence from San Francisco and San Mateo that the actual number is a modest number. I think we can all agree to that, though I don't discount the judge's assessment of the number of people that need to be called, and Mr. Gonzalez didn't argue that either. I think, along with the chair of the committee, I've been among those in the legislature who has advocated as loudly and consistently for restored funding for the courts. And I think that is one of the underlying problems here, is that we just are not funding our courts for appropriate access to justice. But as Mr. Hernandez pointed out, not only do we need to fund the courts for access to justice, but the delivery of justice once in the courtroom is equally important. And as compelling as the proponents' arguments are, I think that where I will continue to fall is on, if I'm going to err, on the side of justice. These misdemeanor cases are very significant cases. They can have long-lasting implications in the lives of those who are tried. And so I'm going to be consistent here, and unfortunately I won't be able to support the bill today.
Senator Stone.
Thank you, Madam Chair, fellow board members, committee members. I'm honored to be here, and thank you for your testimony. And I also support Senator Leno's contention that we need to fully fund our judicial system, not only back to contemporary levels that we've had in the past, but a more modernized formula that gives judges allocated based on population. Because if you look at the caseloads in Riverside County versus the caseloads in San Francisco County, you're going to see a dramatic difference. Our courts are clogged. We don't have any empty courtrooms in Riverside County. In fact, we have an expansion going on in Banning. Thank goodness we got a few extra judges, but there was a time in the not too distant past when you could hear no civil trials in Riverside County because we had so many criminal trials and so many few judges. So this is a question more for the opponents. There was a study done by the National Center of State Courts that said on average prosecutors and defense attorneys only used half of their allocated preemptory challenges. And if that's the case, I don't see the argument of what Senator Block is trying to do, and certainly freeing up resources for the more serious, and I'm not saying there aren't misdemeanor crimes that are serious, but to get to the more serious criminal cases and civil cases, I think is very important. I was like to know your comments, your perspective on that state or that National Center for State Court study.
Madam Chair, Ignacio Hernandez again. I have read that report. It's been a little bit of time since I've read that report. If I remember correctly, the recommendation out of the report was to look at other efficiencies before settling in on reducing the number of peremptory challenge. That's one thing that sticks out from that report. As to your specific question, we don't believe the majority of cases use every peremptory challenge. That is true. I think two things to keep in mind. One is when you do use every peremptory challenge, there's usually a pretty darn good reason, because you have a certain defendant, a certain facts in a case in which it's very difficult to get a fair jury. You can get it oftentimes without using all 10 peremptory challenges, so that's the good thing. The bad thing is in some of the most serious cases, you need all 10 peremptory challenges. The other thing to keep in mind as far as cost is that you cannot file a motion to challenge the bias of a jury unless you have used every one of your peremptory challenges. So the flip side on costs is that now that you're only going to have 6, if this bill were to go forward, then the likelihood of using 6, the maximum number, increases, and then you thereby also increase the possibility or the trigger that a defense counsel can then file a motion subsequently about not having a fair jury. And part of that trigger is that they're out of peremptory challenges. There was someone on there that they can show, look, they made comment, they made a comment that they come and testify on criminal justice reform every single day, yet they said they could be fair. I don't believe that. So we think it's actually going to result in additional costs elsewhere in the court system. And I think that's something else to keep in mind when you're talking about the maximum number.
I appreciate that. And then if I may, with the author, Senator Block, I've sat on a jury as recently as about a year ago. Of course, being a county supervisor, most of the time you're going to get excluded, but you have to go through the process. So I was there at 9 o'clock. We were processed, waiting for about 11 o'clock to get assigned. And then there was a continuance, and then we had to go back to, actually, we were requested in some cases to go to another courthouse. And you may not even be called for jury selection, which means you've given up a whole day of work. And I'm speaking more for especially those in the private sector that, have to work to feed their families. This is going to make more jurors available for the more serious crimes. And at a time when we talk about court funding being low and not commensurate with the kind of judicial services that need to be delivered, isn't it true that this modification will result in really millions of dollars, both in the public sector and private sector, and people having to go and sit for jury trials that may not be called or will be called, and prioritizing those for the more serious felonious crimes? So I'd like to get your perspective on that.
Yeah, there will certainly be efficiencies in the court system in terms of judges, bailiffs, police witnesses, et cetera. But the most important efficiency, perhaps, is that citizens, people won't be taken away from their jobs and their families because of peremptory challenges that are rarely used from 6 to 10. It's just a waste of resources, hardly from the court, but just our constituents. I mean, they get called in and they sit and they don't do anything. And that's just bad for California's economy, bad for Californians, especially when we have evidence or when we have suggestion by Justice Breyer, and some of you weren't here at the beginning, that peremptory challenges are used largely for systematized discrimination against people based on their race, their gender, their sexual orientation. That's not for cause. That's because you think you want fewer jurors who are of a certain race, so you can pull them for no reason. Now, that's illegal. You couldn't say you're taking them off for that reason, but peremptory challenges, you don't give a reason.
Thank you, Madam Chair.
Senator.
Madam Chair, could we
Oh, we could, yes.
Box, and maybe an additional 6 that are the next 6. So the number in the audience changing by a little bit isn't going to change that dynamic.
Okay, thank you.
Okay. Any other comments or questions from members of the committee? Senator Block, would you like to close?
Yes, thank you, Madam Chair. I think we've had a thorough discussion here. This is a fairly modest proposal going from 10 peremptories to 6, as has been said. It puts California in line with 47 other states. The opposition had other suggestions for how we might change the jury selection process. The author is not opposed to any of those selections. Another bill for another day. At this point, your choice is clear. We want to call fewer Californians to come into the jury, miss their jobs, miss their family, so that they can just sit and wait and do nothing. As we've heard, many peremptory challenges go unused. I would suggest we're better off having resources saved for those cases that are most important, most compelling. And with that, I ask for your aye vote.
Okay, thank you. I want to say that I don't think it's a modest proposal. I think it's a pretty profound proposal, actually. One of the reasons we've all supported increasing funding for the courts is because it's the third branch of government and we need a robust court system that is fully funded. We have not been able to achieve that, however. And I am willing to do this with a 5-year sunset. It's a 51% decision. It's one of those things where you have to really weigh on both sides. I understand that Judicial Council, before this bill goes anywhere else, will sit down with committee staff and develop amendments, and that this is part of the bill, that will give us data on the number of people actually called for jury duty, so we know if it changes over time, the number of times all the challenges are used, and information that will tell us the true court costs, if in fact it should turn out not to save money in the end. And the, thank you, type of charge. You're agreeing, right, this is all part of the motion, the type of charge. Some of us will not be here for that discussion, but some of you will. And I hope that there'll be a thorough, if the bill should pass, be a thorough review at that time. So the motion is do pass as amended.
Hancock?
Madam Chair, I apologize for interrupting. I normally don't do that, but with the amendment, wouldn't it be do pass and referred to Appropriations Committee?
No, it wouldn't.
It will
That's
probably,
up to
it will
rules
get
to
pulled
decide,
in,
yes.
rules will do it. It'll get pulled in, once it's amended, it'll get pulled into
Thank you for the
to
clarification.
appropriations.
Thank you. Okay,
Hancock?
aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Leno?
No.
Leno, no. Lou? Lou, aye. McGuire? Aye. McGuire, aye. Mawning? Aye. Mawning, aye. Stone?
Aye.
Stone, aye.
Okay, that bill is out.
Thank you, Madam Chair.
Thank you. Okay, Senator Huff, I understand that Senator Mitchell has agreed to let you go first very graciously. So this, this is item 5, SB 420.